Discovery is complete,
Yes.
and would the people have their witnesses available the 5th?
Judge, I'm not available the 5th, so I was going to ask for the 19th.
Yeah. What happens to people when they ask for dates? Mr. Bellinger? Never mind.
He has a sense of humor.
Will that be acceptable to the people? The 19th. Preliminary examination will be set November 19th, 2024, 9 a.m. That is before Judge Barr.
There are some issues regarding bond that I do hope to address with the court.
Yes.
And I was made aware of them earlier today, Judge, just so you're aware.
It's come to my attention, Your Honor, that the defendant has, in my opinion, been violating the no contact order. I understand the court might perceive it as towing the line. However, he has sent a package with a note to the victim's residence. It's my understanding that the defendant characterized this as sending it to the kids. However, the note in it said, "I love you all so much. Love someone who loves you more than you could possibly know," or something along those lines. And then there's the additional incident of the defendant at least once being seen driving past the soccer fields while the child in common was in practice, after I believe the court explicitly stated that he was not to be at sporting events while the victim was present. So I am concerned at this point. This does seem to be, in my opinion, multiple violations of the no contact order. And I wanted to raise it.
Judge, he did send a package to his kids, which was just blankets for his kids and a note directed to his kids. Granted, the package was addressed to the complaining witness, but
Excuse me?
the package was addressed to the complaining witness, but it was just for the kids. He sent blankets to the kids. And then as to the...
When was that?
The court begins by setting the preliminary examination date after confirming that discovery is complete and witnesses will be available, eventually locking in November 19th, 2024 at 9 a.m. before Judge Barr. Almost immediately after the scheduling, the prosecutor raises serious concerns regarding the defendant's bond, stating that new information suggests violations of the no contact order. The judge confirms he was made aware of the issue earlier in the day, signaling that what was expected to be a routine hearing is about to shift into something far more serious, with the court now focused on whether the defendant has crossed legal boundaries while out on bond.
Your Honor, it was ordered, I believe, on the 19th, but I do also want to put on the record that the victim moved and the defendant had to go to great lengths to find out where they relocated to. So that is another reason I'm concerned. She did not share her new location with the defendant. She did not want him to know where she lived.
The 19th, you said?
Let me confirm one moment, Your Honor.
When Judge Simpson sits back in that chair, it's not a good thing for people that may not know him.
Ordered October 16th.
What was ordered October?
That was when the package was ordered.
Gotcha. How old is the child?
There's 3 children, Judge. How old are your kids?
7, 8, and 9.
7, 8, and 9.
So why was the package addressed to, well, a couple of things. What was the purpose of this?
To send something to my kids because I'm not able to contact them. And it's just something I knew that they would enjoy.
So
I was told that I wasn't able to contact her, and I was trying to abide by that and just send it to my kids. I addressed it to her, not
Why did you address it to her?
It was just something that crossed my mind because it came up as that address. I didn't mean to
What
address
do you
it to
mean
her.
if it came? I don't know what that means.
I didn't mean to address it to her. I meant to address it to them. I just didn't think of that part of it.
Excuse me?
That makes no sense.
I was trying to
You
send my
meant to address it,
to my children.
Corporal.
Uh-oh.
You what?
He meant to send the package to his children.
So why weren't their names on the packet?
Because it was meant as a surprise, because they all had different blankets that they enjoy. And I couldn't.
The prosecutor explains that the defendant allegedly sent a package to the victim's residence, despite a clear no-contact order, and that the package included a note expressing love, which in the prosecutor's view constitutes personal contact. Although the defendant later claimed the package was meant for the children, it was addressed directly to the victim. The prosecutor further alleges that the defendant was seen driving past a soccer field during the child's practice, even though the court had explicitly ordered him not to attend sporting events while the victim was present. Taken together, the prosecutor argues these incidents represent multiple violations and a concerning pattern of pushing the limits of the court's order.
Leave it blank.
He could have just addressed it to the kids. It still would have been a surprise.
I was just trying to send something to my kids. I wasn't trying to disobey any rules. And this is all new to me. I haven't done this before, and I was just trying to send something to my kids.
Okay. How'd you find their address?
So when I was able to move back into my house, the power was off. So we have a list of accounts that we have at our house. And so I got onto DTE to turn it back on. And that's when I saw her address, because the account was used. She used the same account. So I paid that off. And then it was said that I had to create my own account. So I logged off and created my own account. But her address was on there when I logged in. So I paid that bill and then logged off and created my own account.
So prior to doing that, you didn't know where your kids were.
I did not. I didn't do it to find them. I had to turn the power back on my house, and I went to where I knew I had to go.
And so once you see that,
Yes,
then you decide to send the package?
to my kids. Yes.
But Your Honor, there were 4 blankets sent, and he has 3 kids. So I don't really understand what that's going.
Oh, he in the chair. 4 blankets, 3 kids. 1 was for the lady.
All right, I'll ask the $1 million question. You have 3 kids, you're sending them a blanket. Why'd you send 4? Please, you know what?
I don't.
Think about your answer to me. I look stupid, but I'm really not.
It's just all what we used to do at our house when we lived together. They all have their own blankets, and there's an extra one that they use. My son wets the bed a lot.
Oh, hold it. So what you're telling me is you sent 3 blankets, 1 for each of the kids, and then an extra.
Yes, because my son wets the bed a lot, so he needs an extra one.
You gotta be kidding me. Is that your story?
That's what
you're gonna tell me.
What else to tell you? I wasn't to my wife.
Well, the truth would be okay.
The defendant tells the judge that the package contained blankets intended only for his children, explaining that he cannot contact them directly and was simply trying to send something they would enjoy. When questioned about why the package was addressed to the victim, the defendant gives unclear answers, claiming it came up that way and insisting he did not mean to address it to her. As the judge presses further, the defendant admits he discovered the victim's new address while trying to restore electricity at his own home through an old utility account. The judge grows increasingly skeptical as the defendant insists his actions were innocent and that he was simply confused about how to properly send something to his children without violating the order.
You better change it, man, because he don't like it.
That's all I have.
Why'd you send, I'm gonna give you another shot. Why'd you send 4 blankets?
That's what I have because that's what we do at home. That's what we did before. That's how I know what she's done because she's told me. Because my son's extra blanket is actually on the bed at my house right now.
You already sent the
Like
corporal
she
behind
made
him.
the bed when she left and it's still there.
Okay, what about driving past sporting events that she's at?
It's my understanding, but I'll let him explain it. if you'd
No,
like.
go ahead, Counselor.
He was driving his work truck from work to a auto parts store in the same city and then drove back to work right after that. So I don't think he stopped or drove by slow. I think he just happened to be, and I don't think he even knew, he told me earlier today, he didn't know, he knew the kids had practice, but he thought they were not at practice.
How convenient.
Just so I'm clear. You address the package to the alleged victim in this case. Have 3 kids. So you know that there are 4 people that are in that house. You sent 4 blankets, but are telling me they were all for your kids. I miss anything?
No.
Counsel, do you want a hearing on this as to a bond violation?
I mean, I guess maybe, do you know were the 2 of the blankets the same or? If you know, I don't know if you know or not. I don't know.
I don't, personally, it doesn't make a difference to me. There's 4 blankets, 3 kids, 4 people in the house. Package is addressed to the victim. That doesn't make a difference. to me.
Nope.
Judge, I think we don't need to have a hearing. He could
Okay, let me
confess
ask
to-
you this, because I'm about to revoke his bond. So do you want a hearing on this, Counsel?
Yes.
I figured as much. All right. I'll leave the preliminary exam date. I'll set a hearing. On his bond violation. Can everybody be ready next week? Might be appropriate we do it on Halloween.
The judge zeroes in on the most troubling detail. The defendant has 3 children, yet sent 4 blankets to a home with 4 occupants. When asked to explain, the defendant claims the extra blanket was because one child likes to bundle up, an answer that visibly frustrates the court. The judge repeatedly gives the defendant opportunities to clarify his reasoning, but each explanation only deepens the inconsistency. The court also addresses the allegation of driving past a soccer field, which the defense dismisses as coincidence, prompting the judge to sarcastically remark on how convenient the explanation sounds. At this point, the judge makes it clear he views the situation as a pattern, not a misunderstanding.
Judge, I can't do it on the 31st. Unless we do it, or I guess I could do it right at 1.
Right at 1, yeah. You don't know how my days work.
Oh, I know,
But
I
mean,
know.
I can, well, we normally set it at 3, but I don't know if that's gonna cut later causes you a problem.
Yes.
So,
I just had something at 10 and 3. So I was like trying to,
there's no way for me to predict what that docket entirely will look like. What about the 7th?
I'm in an assault with intent to murder trial that should be ending at that time. So I think we could schedule it that day. I should be done.
All right, I'll set a bond hearing on his bond for November 7th, 2024 at 3 p.m. I'll still leave the exam date in place. All right,
Thank you, Judge. So it'll be here at 3 p.m.
3 p.m.
Thank you.
All right. On that date, at this time, given what the court has heard, Defendant's bond at this time is revoked. Defendant's remanded.
Judge, can he have some sort of cash bond with maybe a GPS tether just to allow him to continue working? He was living at his job until recently. He had to move when he moved back in the house.
Revoked his bond.
I know.
No, I understand what you're asking, and I'm going to deny that request at this time.
Okay.
All right.
After summarizing the facts, the judge states that the package was addressed to the victim, contained items matching the number of people in the household, and followed the defendant obtaining the victim's address despite her intentionally keeping it private. The judge asked defense counsel whether they want a bond violation hearing, then announces that based on what has already been presented, the defendant's bond is revoked immediately. A request for a cash bond or a GPS tether is denied without hesitation. The judge orders the defendant remanded into custody pending a bond hearing set for November 7th, 2024, making it clear that no contact orders are absolute and that attempts to work around them, even under emotional circumstances, will not be tolerated.